rebuttal.
Good evening, and may it please the Court. My name is James Puddington, and I am representing Petitioner B613 Reinsurance Consortium. Today I will be arguing that the Court of Appeals erroneously applied the proximate cause standard to the FTAIA's direct effects requirement, and therefore this Court should adopt the immediate consequence standard for the direct effects test for three reasons. It is supported by the text of the Act, it is consistent with congressional intent to adopt a clear and predictable standard, and it properly respects the principles of international comity. Beginning with the text of the Act, the plain meaning of direct in the FTAIA supports the immediate consequence standard. This Court has held in Perrin v. United States that where a term is not explicitly defined in a statute, we look to dictionaries to determine the plain meaning first. In a dictionary published contemporaneously with the Act, Webster's Dictionary, the primary definition of direct was an immediate consequence definition. And in addition to the Webster's Dictionary, other authoritative dictionaries, such as the Oxford English Dictionary and the Black's Law Dictionary, all support as their primary definition the immediate consequence standard. In Muscarello v. United States, this Court held that the primary definition of a word is dispositive as to its plain meaning.
But just jump in. Is this test question whether you're in the proximate test or you're in the immediate consequence test, is that outcome determinative in this case?
It could be, Your Honor, because the district court did rule under the immediate consequences test that there was not adequate standing under the FTAIA for Sherman Act jurisdiction, in this case for respondents. However, that outcome did change under the Court of Appeals, which remanded under the different test, the proximate cause test, which may have, since the proximate cause test looks to possible attenuated circumstances or tertiary effects, instead of an immediate direct effect that the immediate consequence test, it is possible that different outcomes could happen. And indeed, that is one of the problems with the proximate cause standard, because it could result, being such an amorphous and hard to predict test, it can result in many thousands of foreign conflicts coming into U.S. courts, forcing us to be the policemen of the world in this antitrust area. Whenever even a foreign company engages in anti-competitive activity against another foreign company, as in this case.
Because see, the conduct here is pretty egregious. I mean, if this happened on the U.S. shores, there'd be no question this would be an antitrust violation, right?
The conduct as alleged is definitely can be considered egregious, Your Honor, but under the immediate consequence standard, which has been adopted by this court for when Congress uses the term direct, this court in Weltover held that the immediate consequence standard should apply. And under that standard, this court has held, only the direct target of the actor would be the target with standing under the FTAIA to bring a Sherman Act claim.
So who is that in this case? Who are the acts in this case are directed at whom?
The parent company, the Australian company that is the parent company of the...
Doesn't the record suggest that the policies here cover the subsidiaries as well?
Yes, the policies do cover the subsidiaries, Your Honor.
Isn't it the intent to reach all of the covered entities in the policies?
Your Honor, I believe the intent of the alleged actions by Petitioner in this case was to force not respondent, but respondent's parent company to adopt different measures in its insurance contracts, which then would bind its subsidiaries. But the intention was at the respondent's parent company itself, and could have had effects not on just respondents here, but on many international subsidiaries in the world.
Is it not the case that the subsidiaries capable of buying reinsurance as well?
The subsidiaries are capable, yes, but and that is why under the immediate consequence standard we would look to whether if the subsidiaries had contracted directly with a type of actor who, as the respondent's alleged petitioner to be in this case, had directly boycotted those subsidiaries.
Isn't that just aren't you folding the consequence here into Illinois BRIC and deciding and arguing to us that you need to be a direct purchaser in order to have standing? The question that is before us whether the actions here had a direct consequence, under whatever standard we want to hold it, on the American entities.
Yes, Your Honor, but direct is in itself a limiting principle. So while there may have been effects, some tertiary effects that may have been felt by subsidiaries in America, because the direct targeting, even under the Alcoa standard, for example, which under antitrust law has historically been the common law, it required targeting at the target to have the effects required. In Hartford Fire, for example, when the court applied the Alcoa test, that case was very factually distinguished from this case because in that case, the actor directly aimed its actions at insurers in the United States with no intervening party, while here there's an Australian party who was the direct target. And Your Honor, I would just submit that there is no problem with respondents going to Australian court or with B613 being a group of European insurers. The respondent could have gone to any of those courts. So there are many jurisdictions in the world available for these types of original plaintiffs.
But these plaintiffs are admitted insurers in the state of Albers.
Yes.
That's who these plaintiffs are.
Yes, correct.
Why can't they avail themselves, these admitted insurers in Albers, why can't they avail themselves of the federal court in Albers?
Well, precisely the intention of the FTAIA, Your Honor, was to, first of all, limit the extent of the Sherman Act to not apply to foreign extraterritorial activity, and then bring in some of that activity back into the realm for petitioners, not petitioners, but respondents like those in Albers to engage in. And that is the effects test, which is at issue before the court today, which requires direct, reasonably foreseeable, and substantial effects on U.S. domestic commerce.
And deciding that you will not reinsure the risks that these admitted insurers in Albers have, in some way does not have a direct effect on them because they have a parent company?
That is correct, Your Honor, not a direct effect. And Congress, if they wanted to adopt a proximate cause standard, they could have used the term proximate itself. In fact, Congress, this court has ruled that there's a presumption that Congress intends to use the specific terms it uses in statutes. And historically, Congress has used the term proximate when it intended to use a proximate cause standard.
But it didn't use direct consequence, did it? Immediate consequence in its wording in that statute either.
It did not use the specific wording, immediate consequences, but it did adopt the same standard that was used in the FSIA, for example, the Foreign Sovereign Immunities Act, which this court in Weltover held to be the immediate consequence standard.
There are significant differences between those two statutes.
There are, Your Honor, but when we apply, when this court has applied the canon of in pari materia historically, there are always ways to distinguish statutes, but actually the FSIA structurally is very similar to the FTIA. For example, both provide general immunity to foreign actors with specific exceptions in the FSIA, including where action is based upon a commercial activity carried on in the United States by a foreign state. This is very reminiscent of the type of exception present in the FTIA for exceptions for commerce affecting domestic American commerce. And the FSIA was enacted only 6 years before the FTAIA. So Congress clearly intended to adopt the same type of direct test it wanted in the FSIA with that it used in the FTA.
The consequence of not allowing a U.S. forum is potentially to allow the insurers in this case the reinsurers to force a much less favorable set of coverage opportunities for American companies or international companies practicing in the States. Isn't that true?
It is true, Your Honor, and while the immediate consequence standard is not as broad as the proximate cause standard, this was explicitly intended by Congress. This court in Empegran in 2004 held that the intention of Congress was to create a clear standard, was to assuredly clarify the FTIA, not to expand the FTIA, and perhaps to limit, the scope of the Sherman Act under the FTIA, perhaps to limit that scope. And it did this because it knew that foreign businesses wanting to trade with American companies would be better facilitated with a standard that they could predict their liability under, especially in this interconnected global economy. An amorphous and hard to determine test such as proximate cause would cause many actions coming into the United States under which companies would never be able to predict their liability. Even considering it separate from the reasonable foreseeability standard, even if they could foresee perhaps some tertiary ripple effects on the U.S. economy, they could not surely foresee the liability would arise under the Sherman Act, which is why they limited it.
Well, but I guess the concern I have is just, you're basically denying American companies the benefits of the American laws on commerce that protect them from, anti-competitive behaviors like, coercive, boycotts and things like that. And in this case, it has the further effect potentially of leaving American policyholders in a position where they're not going to be able to buy the same coverage because of reinsurers outside the U.S. pressuring the insurance companies that are admitted to sell insurance in the United States and in Albers, for that matter, the more favorable occurrence policies as opposed to claims-made policies. And doesn't that create a very troubling concept?
Well, Your Honor, if you look outside of the direct effects exception for the FTIA's exempting of Sherman Act applicability, there's also another blanket exception for import commerce. And typically, companies who want to engage in anti-competitive conduct to, for instance, raise prices in the United States have some corresponding benefit with that raised prices, so they're probably also engaged in trade in the United States. So the import commerce exception would also have a significant bite. In addition to that, there has been 100 statutes, antitrust statutes enacted since the implementation of the FTIA. So there are multiple jurisdictions for U.S. companies to engage in antitrust lawsuits in. And additionally, Your Honor, while those are important policy considerations, the immediate consequence standard does properly respect principles of international comity that the proximate cause standard does not. For example, this court has read statutes to avoid unreasonably interfering with the sovereign authority of other nations in Empegran in 2004. Many foreign antitrust laws differ in some ways with U.S. laws, such as not having treble damages but still compensating plaintiffs, so plaintiffs could still be compensated without interfering with other nations' laws.
In your statutory argument, you seem to me to avoid focusing on the critical word "unless." And the statute seems to me to prescribe circumstances in which the Sherman Act's reach would be apposite. And those, that "unless" word, I don't understand your argument to exclude anything. I read your argument to be everything is excluded and not to address the exceptions to the general rule, the chapeau or whatever it is called in the case law. Do you not acknowledge, or does your argument acknowledge that there are circumstances under which the word "unless" would require coverage of cases?
So if I could just
Address it any way you want.
So the "unless" word in that statute could be saying that these are some exceptions, but there may be others not explicitly listed in the statute. Was that what Your Honor was asking?
It's a response.
Well, what I would say to that is the FTIA does not completely go against the common law. There has been a common law which addressed this issue before the enactment of the FTIA, the Alcoa test, which required for there to be any Sherman Act application at all, there had to be intent to affect and actual effects on U.S. commerce. So there was a specific set of applications for foreign applicability of the Sherman Act. And this was meant to codify, perhaps amend and limit it a little bit, but codify that.
So let's clarify. So how does the test that you're articulating clarify the Alcoa standard or the American banana standard, for that matter? How is it that the FTIA clarifies it?
Well, Your Honor, the Alcoa standard does not give a specific test for effects itself. It just states that it has to be intended and actual effects. It does not give the limiting principles for those effects, and the FTIA does so. Thank you, Your Honor. Your Honors, I would just like to briefly respond to one of respondents' textual arguments. The immediate consequence standard for direct would not render the reasonably foreseeable requirement superfluous. It is, while reasonable foreseeability pertains to the objective availability of information in the market to the actor, the immediate consequence standard would relate to the logical immediacy between the act and the effect itself. And there are possible examples that can be imagined of the actor not knowing of certain market conditions, but taking actions that may have immediate consequences on others. Thank you.
Congratulations, first of all. I'd like to say that everyone we thought did a great job. We wanted to select the speaker of the night, or it would be James Puddington. Good job.
Hard decision to make. Right?
Yes. But we also wanted to say, kudos to all four of you. This was a complicated arguments on both sides, both issues. I personally was still trying to understand a lot of it while asking you questions, and we will give specific feedback upstairs, but nice job.